Thank you so much, Chanda. As she said, I'm a research fellow with the Center for Agriculture and Food Systems. So just to give like a little introduction to myself and where I'm coming from, we are a research center that is based in a law and graduate school, and we create public-facing resources on legal and policy issues throughout the food system. So I'll also give a quick plug. I brought a few of them today, and throughout the conference, we'll have them on a table kind of on the way to the restrooms. But one that I'm going to be building off of more today is specifically about defensive publications. And so kind of two caveats as we start. One is that I am an attorney, but I am not a patent attorney. And so I am coming from a little more of a generalist perspective. And then secondly, I am an attorney, not a plant breeder. So I sometimes have to be corrected on the science, and please, anybody feel free to do that at any time that it is warranted, because that's definitely an area of complexity that I still stumble over pretty regularly. So Paulina actually gave a really great introduction this morning to the patent system, and particularly utility patents as they apply to plants. And so I'm just going to refer back to that a little bit in that, so a patent grants the patent holder, who we often think of as the inventor of a new invention, a time-limited monopoly on commercializing their invention, and it's 20 years in the US. But for an invention to be patentable, it does have to meet the 4 criteria that Paulina talked about. And the one that's most relevant to defensive publication is novelty. It needs to be a new invention that is not already known within the existing body of knowledge in a particular field. So in this case, plant breeding. And that's what we refer to in the law as the prior art, is like this body of knowledge that plant breeders have. It doesn't mean every single person knows every single thing, but it means that it's known by more than, the one person within their own head. It's something that it's a body of knowledge that a diligent plant breeder could access if they're looking for this information. And so defensive publication is like actually just this really simple idea that if you have knowledge or have developed, a particular variety or particular traits in a variety, that if you get that knowledge into the prior art, if you get it out into public where it's known by other people, then that should stop somebody else who develops it later from being able to get a patent on it. So that's like the very simple kind of idealized version of how that might work. And then it gets a little bit trickier in the details. So as Paulina mentioned, what can be considered prior art is just a huge range of almost anything. So sales of a particular invention. And I know invention, to me at least, it feels like sometimes a weird way to talk about plants, but I'm still going to kind of lean on the legal terminology, even recognizing that it's not a great fit necessarily for every situation. But so sales of a particular type of seed would be considered prior art. Even if somebody didn't buy it, putting something up for sale is considered part of the prior art. So if it exists in a seed catalog and literally no one ordered it, that could be still considered prior art. Public use. So if people are using it, whether or not there's any kind of commercial transaction, that can be considered prior art. There's this sort of catch-all category called otherwise available to the public. Super nebulous, but the idea is if people can access this knowledge or this invention, then it's part of the prior art. However, for the prior art to really matter kind of in a legal sense in terms of a patent search, it has to actually be found by the patent examiner. And in that sense, sometimes some of these more nebulous areas that theoretically or legally are considered part of the prior art aren't necessarily the most practical way of actually trying to get that information found in a search. And so two of the kind of bodies of prior art that are maybe more reliable are patents themselves or existing patent applications. And what the law refers to as printed publications, which is still a little broader than meaning like physical printed publications. And so two ways that people sometimes think about trying to prevent others from patenting inventions that already exist and are already in use by other people. One of them could be defensive patenting. So if you're developing something that's new and potentially other people are working on the same thing, like Paulina gave the example of long stem broccoli. One thing you could do is try to apply for the patent yourself. And if you do that before anybody else files a patent for it, then that's going to go, kind of time stamped in the record, and preclude somebody else from being able to patent the same invention. And so that's a strategy that gets used in some fields and by some actors, and it has some, definite pros to it. One is that if you actually get the patent, you get the time-limited monopoly, and that can be a benefit to commercialization. Another, thinking from a defensive posture, one benefit to it is that that's definitely going to get searched in a subsequent prior art search by a patent examiner. So having something in a patent application, or eventually if you're granted the patent, like that's a really good way to make sure that it gets found later. On the other hand, there are drawbacks to that approach too. One of them is cost. One of them is the time commitment to go through this process. And then a third is just what can be kind of a cultural drawback, that's not necessarily a good tool for people who don't feel like they want to buy into the system of patenting plants or plant traits. And so that can be, not a good fit for some people.
Emily,
Yes.
could you distinguish between defensive publishing and defensive patent?
Yes. Yeah. So that's defensive patenting. That's going through the patent process yourself in an effort to prevent somebody else from getting a patent on the same, essentially like the same thing. And then defensive publication is an approach with the similar goal of preventing someone else from getting a patent, but instead of trying to apply for the patent yourself, what you're doing instead is adding to the body of prior art through publishing information about what you're working on. And so oftentimes that might be something like publishing in a scientific journal. It could also be publishing on a blog. There's a really wide variety of what that could mean. Legally, the requirements are, one, that it needs to be accessible to the public. That doesn't mean it needs to be free, but it does mean that it can't be, for example, within a confidential memo within a company. It could be in a journal that has a paywall that could be considered accessible. But basically, it needs to be something that a reasonably diligent researcher would be able to find if they're looking for it. And the kind of standard that the law looks to is a researcher within that same field. So it doesn't need to be you know, a random person off the street. It's somebody else who's in the plant breeding field. You know, would they be able to find your publication if they're looking for it? So the kind of pros to that approach, first of all, it can be very cheap. It can be very easy. Often it can be, you know, especially for you know, for folks who are in academia, it might be something that you're already doing as as part of your academic role. But it has some drawbacks too, and particularly where I think it can be tricky is that it sounds like it's really easy, like just, you know, publish this information and then great, no one can get a patent. And legally that's kind of like, we would say that that's the legal reality, but it's not really the practical reality necessarily, because it does actually have to be found by a patent examiner who is looking for it. And so one of the kind of challenges that comes up, and Paulina talked about this a little bit, is that there isn't necessarily one standard place to put this publication where you know it's going to be found. There might be a variety of pretty good options, but it's not, it first of all has to be somewhere that the patent examiner will find it. And it secondly has to be enabling. And basically that means it has to be to about the same degree of specificity that somebody would put in a patent application. So, so if a patent examiner were to find what's been published, they could look at it and say, oh yes, I can see that this is the same set of traits that, you know, this other patent applicant is trying to claim. Like I can see that this is an extra long stem on the broccoli. I can see, you know, whatever the other relevant traits are. And so it's important for defensive publications to have that degree of specificity. And then we'll probably talk about this in a little bit, but at the same time, there's like this tension with the fact that often people applying for patents are trying to claim things as broadly as possible. So it's like ideally a defensive publication would be as broad as possible, but then if it's too broad, it's not clear that it's precluding a later claim. So I think that there's some tension there. And then I think another thing that needs to be borne in mind is that because defensive publication is making information public, it's not necessarily an appropriate tool if it's information that is meant to be kept within a particular community, for example. And so it's not always the best approach, basically, for every situation by any means. So I think there's some tension there too, and especially when we think about you know, varieties that have been cultivated for many generations, and plants where there might be a lot of different possible traits or possible, you know, strengths, and there's this question of kind of how to capture all that in a defensive publication and, you know, when it's appropriate to do so.
Okay.
So I'll just kind of put that out as an intro.
Okay. So then the question becomes, how does that align with trademark in your trademarking? Or does it?
Hi, y'all. Well, I don't think, I think trademark is kind of a completely different scenario and section, and is used very differently because trademarks are used primarily for commercial transactions. So a trademark has to be something that's being sold or has to be on something that's being sold. So yeah, I can talk a little bit about, I'm coming from the Land Institute, which is a nonprofit organization that develops perennial grain crops. So we we work on several different crops, but the crop that's kind of furthest along and that is out in the world is called Kernza. And Kernza is the trademark name under which the seed or grain of intermediate wheatgrass is sold. So not just any intermediate wheatgrass, but improved varieties are sold. And those improved varieties have to be approved and put on the list by the Land Institute. We hold the trademark since we own it. And then those, if a variety is, it can then be sold, the grain or the seed can then be sold under the trademark name. So it works a little bit differently. It's not highly defensible in the same way that a patent is highly defensible, because it's only really on the commercial transaction. So products that contain Kernza can use the trademark in the name, but that's kind of where it's different. There's not a complete, there's not a patent that's saying that is telling anyone anything they can do with regards to breeding or anything. So you could take that Kernza seed, you could plant it, you could do whatever you want with it. You could breed a new variety, but unless the Land Institute then subsequently would approve that variety to be called Kernza, you couldn't call it Kernza, if that makes sense, because we own the trademark. So we sort of like get to decide how the trademark is used and on what kinds of products it can be used. So initially, when the conversations were happening about whether or not we should trademark the name, our lawyers advised us that we should, because without a sort of legal definition of this new grain crop, you could sell anything and call it that. So if you were in the marketplace and there was no legal protection, you could sell a bag of rocks and say it was Kernza. You could sell barley seed and say it was Kernza seed. And having this sort of legal definition and an ownership around what that trademark name meant prevents that from happening, or provides at least legal recourse for the trademark owner if that should happen. And it also requires of us that we then develop a sort of standard for what that grain or seed is and how it can be moved through the marketplace. So we have an identity preserved program, which means that, we know where the seed was all grown, and we know where, and it has to meet certain standards, excuse me, in order to be sold as Kernza seed. So that's an important thing that the trademark governs, or that the trademark sort of builds the boundaries around how we govern that we wouldn't be able to do if we didn't have some sort of like legal protection or provision for that happening. So otherwise it would sort of be a handshake agreement that we want it all to meet these standards, but we wouldn't be able to say it has to meet that standard in order to be sold under that name. So an example is pretty common in grains are things like it can only have, a certain 1 part per million of DON or vomitoxin. So it helps us also protect both the quality of the grain and the quality of the food that goes out to consumers under the trademark name. So that was a big reason, in terms of why we chose to go with a trademark and how we wanted to use a trademark to build kind of the protections around what this grain was and how it was defined in the marketplace. Of course, the Land Institute as the owner has a lot of power in terms of how we license the trademark to be used. So we can license it to companies, growers, et cetera. So right now we license the trademark to growers. So growers are growing intermediate wheatgrass for the production of Kernza grain that they can then sell. And we also license folks in the middle of the supply chain, so distributors who are working with Kernza, processing it and getting it ready for the market. And then we also license at the business level. So if you're a business that's buying grain direct from a grower, you also need a Kernza trademark license. The distributors are allowed to sell to their customers, so it's a little bit of a different license. They can sell to their customers without those customers needing an additional license. So they have what's called a sub-license that's built in. That all is very complicated, and it is probably one of the most complicated ways to manage a trademark. I think if we were to redo it, we would probably simplify it by maybe just licensing at that point in the middle of the supply chain, so that those folks could go ahead and contract and use a sub-license for growers and a sub-license for end use businesses. But we didn't do that early on. We're still kind of in the process of figuring that out. And initially, we didn't want to do that because we really wanted to use the trademark as a way to bring people into a community where all the licensees, all the people growing the grain, all the people using the grain in the marketplace were able to have a voice in how the trademark was managed and governed. And I'll just kind of address some of the challenges of doing it this way. I mean, first of all, it's a big undertaking and it requires a lot of just management. We have 100 licensees. So tracking those folks down for audits, which is part of kind of the legal requirement to ensure that you're enforcing the trademark. So we have to track those folks down and we have to make sure that we're in communication with them. And maybe it was a grower who was interested and they no longer grow, and then you have to retire those licenses. So it's a lot of like kind of paperwork in a way, or, it's digital paperwork at this point. But all of that, I think all of that complexity and difficulty, one of the things that I think we've greatly underestimated, probably just as a society, is that it requires a ton of relationship management. And the amount of relationship management, organizing, that is something that I think if you're thinking about using a trademark in these ways is really important. So especially in the realm of using the trademark to sort of build a space where the licensees have a lot of input, that requires a ton of management and organizing and socialization and building relationships amongst people. And what we found is that we underestimated the capacity that it would take to actually do that. And in the absence of folks whose, full-time positions are dedicated to building those relationships, we kind of default to these systems where everyone sees themselves as an individual business and therefore in competition with everyone else. Mm-hmm. Even though the marketplace is tiny, right? There's really no need to be competitive at this point, but it's the default mindset, I think, of both the farmers, the businesses, and the entrepreneurs who are involved, is that they're all in competition with one another or potential competition with one another. And so building those relationships, I think, and building a different kind of cultural fabric is something that, if you want to do that, you have to be attentive to the kind of capacity it's going to take to do it.
So
yeah,
we're going to move on.
Yeah.
Okay. So Julie, you're going to be talking about material transfer.
Yes. So, is this on now? Okay. I will start by saying that I am a plant breeder. I am not a lawyer. So feel free to correct anything that I say that is not correct. I'm going to talk a bit about contracts as a way of exchanging varieties or experimental early generation plants that can be and often is seen as a barrier, but can also be a fairly easy way to define your own terms for that exchange. And so contracts are an agreement between two entities, and they're usually governed by state law, but you can write your own contract as long as both parties agree to it. So you don't necessarily need a lawyer to do this, although you might want to have one look your contract over. Material transfer agreements can be very short. They're a form of contract, but usually you don't use a lawyer to actually draft one. I want to kind of distinguish between two different kinds of contracts that I've seen, and this is mostly based on my experience both running trials as part of the Seed to Kitchen Collaborative, where we're working with a lot of different breeders in the public and private space, and also as a plant breeder, working with other plant breeders. And then some as an academic collaborator with the USDA Seed Liaison Project, where we have been talking to a lot of different groups about contracts and other IP-related issues. So there are contracts that are often referred to as bag tags or technology use agreements, which accompany commercial seed. And those are generally contracts of adhesion that you agree to by opening the bag of seed, or that you have to sign to get seed. And those are typically not negotiable. So you cannot go to the seed provider and decide you want different terms of that contract. I mean, you could, but they would probably say no. So those typically are not real flexible. And those can be barriers to entry for a breeder if everything that they are interested in potentially working with is covered by one of these bag tags or technology use agreements. I don't want to focus on those today. I want to focus on material transfer agreements or MTAs and licenses, which are typically much more flexible. It can sometimes not feel that way. It certainly can feel that way if it can feel like it's, kind of constraining if there's a power imbalance between the two parties. So that I want to recognize does frequently exist and can be a real barrier to getting something that is on your terms. But you can always ask to change the agreement before you sign it. And often if you're working with a plant breeder at a university or at a nonprofit, they may not be the one drafting the contract that their organization sends out. And I've certainly had breeders, they're like, can you send me what they sent you? What my organization sent you? And I send it back and they're like, they sent you this? All right, here's what we want to change. So it's not always that the breeder has defined the terms and that's what they want to do. But often the terms are, reflecting certain principles. And so I think that it can get complicated when you have a lot of kind of legal terminology and every other word is capitalized or, in quotes. But if you get down to kind of the principles, then it may be easier to see kind of what the purpose is and how you want to shape it to reflect what you want to govern that exchange. So the main things I look for when I'm reading an MTA that's coming in or drafting an MTA is, what do I want to protect? So if I'm the one sending out a bag of seeds, what do I want to make sure the person getting it does? And that could be, I want to make sure that they send me back the data from their trial. I might want to make sure that they don't distribute that seed to other people who haven't agreed to the kind of principles of everyone's going to share data. I might want to make sure that they don't use that seed directly in commercialization. Or I might be fine with them doing anything with the seed as long as they don't patent it themselves. And all of those things can be in an MTA. In general, there are a few different types of MTA. One is if you're exchanging seed only for the purposes of trialing something. So the intent is not to start a breeding project or to do anything other than test it to see if it does well in your environment. And for those, usually what I want is to see that if I'm receiving seed to do trialing, that there are no restrictions on my ability to publish that data and to share it publicly. And if I am sending seed for a trial, I want to make sure I get back the data that they collect. And I want them usually to publish it as well. And that can go along with defensive publication, because if you're participating in a trialing network with your new variety and you're sending it, essentially saying, I want you to trial my variety and I want you to publish the data, and that's in your MTA, then it will be publicly available data that you can then cite in a publication, or maybe it's already, online and available in terms of performance. So for a trial only MTA, I'm not as worried about whether I can save seed or whether I can use it for breeding, because the goal is I want to test it and I want to make sure that I can distribute data to people about how that variety did. There are other MTAs that are just for distribution. I am sharing something with another party, or maybe I'm getting something from the USDA National Plant Germplasm System or from Seed Savers Exchange or another organization that stewards germplasm. Those MTAs are often very short, and they essentially say, please give us credit if you do something with this material. Credit us in publications, credit us in terms of what you develop with it. And that's really important. Like, credit is usually just as important as money in the plant breeding community, like being recognized for the work that you do. And then there may be a restriction on whether you can distribute that to somebody else. So if I get something from the National Plant Germplasm System, they may be fine with me sharing it with other people, or they may want any requests to come through them. Usually in the distribution MTAs, they don't want you coming back every year and asking for more seed, which is different than the trialing MTAs, where the trialing MTAs may say, you must come back to us for seed every year. A distribution MTA usually will say, you should have your own seed stock because we're not going to send this every year. And so those usually have some clause about you may or may not distribute it to third parties. Sometimes it's you may distribute it as long as they agree to the same terms. And there may be a clause that says you essentially cannot apply for your own IP on this material because it's not yours, it came from us. And so prevention of the recipient from seeking a utility patent or other IP on it is something that you might see in those MTAs, and that you can write into your own MTAs if you're distributing germplasm. And then the third type is an experimental or a research and breeding MTA. And these are the ones that may get longer, but also can be written in a very succinct way. A lot of the MTAs that I work with for research are based on the Wheat Workers Code of Ethics, which kind of spells out what is fair use of the received material in your own breeding program. Often that is, you can test it, you can save seed, make a cross, and develop something new, but you can't make multiple crosses back to the material that you received to create what's called an essentially derived variety, which is something that's too close to the original and kind of copies it.
Could you repeat that?
It's called a essentially derived variety, and it's in the Plant Variety Protection Act. It's defined there. It's not defined extremely clearly, but it is something that is well recognized in principle, because it is trying to prevent somebody from taking a variety that somebody else developed, making a very small change, and then commercializing it themselves without giving credit or licensing the original variety from the original breeder. And so MTAs that follow kind of the same pattern as the Plant Variety Protection Act allow you to make crosses and use that variety in breeding, as long as you're not commercializing something that's too close to the original variety. And they require you to have a license if you want to commercialize the material that you received directly, or usually they require a license if you're using it as a recurrent parent, or you make multiple back crosses to that variety, or as an inbred parent in a hybrid variety. Those I will give to the organizers some examples. We decided we weren't going with slides here, so I don't have them up in slides, but I'll give you some examples of each of those afterwards, because I know it's hard to describe in words. Those are the three big categories. I think the main thing to realize is that there are a bunch of examples out there that you can use to tailor to your own purposes. It doesn't have to be complicated. It's mostly to get your agreement with the other party on paper so that everyone's clear about that agreement. Sometimes with universities or with other institutions, they can get kind of long, but you can always ask questions and negotiate. And it can be a very flexible way of just ensuring that your intent in sharing that is respected. They can also obviously be a barrier if they get to be very restrictive and they are, seen as non-negotiable by the originator. But I have had fairly good success in negotiating MTAs that I feel like were too restrictive, and in using MTAs to facilitate the kind of the trialing process with the number of different public and private institutions.
So I guess my question, because we're talking about different levels of legal complexity. So I guess my question would be like, what's the most common misperception that people have around your particular brand of, and after that question, I'm going to open the question and answer.
So in terms of what we were asked to talk about?
Yeah.
Okay. So for MTAs, I think the most common misperception is that they are something that's given to you that you just have to sign or not sign, and that they are complicated and require a lawyer to actually get through. That is it's a misperception only because it doesn't have to be that way, not because people might not experience that way, right? You may very well be given a very long MTA and be told like, take it or leave it. But it doesn't have to be that way.
I think for trademarks, maybe the biggest misperception is that like the reason to use a trademark is to make millions of dollars. And really like managing a trademark costs money, managing the relationships costs money, all of those things. So it can also be used, I think, to try and build a bounded space for community to be involved. Yeah, so that's probably the biggest misperception. There are different ways to use it, and that it isn't always about like the easiest way to make money.
Thank you.
I think I would guess that for defensive publication, maybe the biggest misperception is that what the law says is what happens in reality. And I think it's just important to realize that it's a very human process, and maybe more depends on actors in the process than on, let's say, the law as written in terms of determining what the actual outcomes are.
So are the mics on? Okay. So we're going to open the question and answer session. Thank you, Lady.
So Julie, I understand in a trialing MTA why, in the context of defensive publication and prior art searches, it would make sense to want someone to publish the data from their trial. But is the MTA itself something that could pop up in a prior art search, or is it confidential?
it's not usually confidential, but it's not also publicly available. It's kind of an internal document that you both sign. So if you put it on your website or something, maybe people would find it, but usually it's like an MTA, and then the varieties are listed at the bottom or in an appendix, is like, these are the things you're actually talking about. And so I would not expect anyone to be able to actually find that, even though it's not a confidential document.
Okay, thanks.
Okay, I have lots of questions, but my burning question is on bag tag licenses, which Julie, you said you weren't going to spend a lot of time on. But the question that I've grappled with is generally it's the big seed companies that have these bag tag, the verbiage on their packet that you read, and then when you open the packet, you're bound by those terms. But what if the seed comes to you through a retail outfit where they're repackaging the seed, so you're not seeing that language on the seed when you get it? My interpretation is that you're not a party to the contract, and so you're not held by those terms. But I would be interested in your Julie or Emily, in your interpretation on that.
Yeah, so that is also my understanding, but I am not a lawyer. You're the one that's supposed to have all the answers, Jim.
My understanding is pretty limited by not having the experience of going to purchase the seed, but my educated guess would be that if it really is just walking into a store and getting rebagged seed with no tag on it, that you're not a party to the contract and you're not bound by its terms. On the other hand, my kind of secondary understanding is that in at least some instances that growers aren't able to make those purchases without having signed a licensing agreement with the parent company. And in that case, often those terms would be either directly incorporated or incorporated by reference from that. So they would still kind of, in a roundabout way, end up being bound by them. And for anyone who wants to learn more, we have a new publication out just this week. You are the first to have access to it, and anyone can, that's on those licensing agreements, and anyone can find me, or we'll have them out on a table during the main conference.
We love a good shameless plug. We just do.
I have a question about near commercial lines. So say hypothetically that I had some near commercial lines of winter pea that I wanted to distribute to farmers and gardeners to trial and get data back to support their future release to a seed company that would multiply and distribute them. If I wrote in a short MTA that the seed was for trialing purposes only, and folks are not permitted to save the seed, is that sufficient to have that seed not have been in the public domain so that it could be licensed to a seed company in the future?
Yes, so my understanding is that yes, if it's distributed under an MTA that says it's experimental seed, not for commercial use, and that it is not allowed to save seed. I don't even know if you need that piece, but
Okay,
you need that they cannot sell it commercially as seed.
gotcha.
They can sell it commercially as grain. We've
Right.
done that, and I can show you an example of one where growers are allowed to sell produce, but not seed.
Yep.
The main thing is that for most of the IP, so if you wanted to say get a PVP certificate,
Yeah.
you need to do that within a year of the first commercial sale of the seed. And so that MTA makes it clear that it's not a commercial sale of seed, it's a trialing agreement.
Yep, thank you.
Yep.
Benita?
And there are a lot of plant breeders with more experience than I have, so please jump in if I say something wrong.
So thank you. This has been very instructive. I'm ready to get into the fight now. But you gave me one question. You said one thing I couldn't properly digest, and you talked about specific traits that you needed to mention. I'm talking about prior art because that's what I most understand. So could you give some examples of what the traits are that we need to be putting in our publications, in our blogs, in our newsletters, in our catalog that would differentiate that and make it available for prior art?
Yeah, so it would be, I would say any traits that would be, I mean, I would say put everything you've got. But any traits in particular, things that you think somebody would be interested in trying to commercialize or trying to patent. So, and I definitely am not the person with the best understanding of, what that variety of traits might be, but, I think about it being things like different resistances or tolerances, or, is it, I don't know, extra tall or delicious.
Yeah.
I gotta stop.
One thing,
I appreciate it. I know.
yeah, I think basically, yeah, what you see as its unique characteristics. One potential like practical way to go about this is if you take the closest commercially available variety that is definitely described, maybe it has a PVP certificate on it, compare your variety to that variety and say how it's similar and how it's different. And you might even go to the PVP website and download their kind of application guidelines. For each crop, they have a set of what they call exhibits. And there's one, I think it's exhibit B, where you essentially say what the good characteristics of your variety and compare it to the closest commercially available variety. And then exhibit C is a very long list of potential morphological characteristics that could differentiate that variety. And that you can kind of write down all of the things that you think are relevant. Maybe it's flower color, maybe it's height, maybe it's the leaf color. They're not things that are directly relevant to production, but they can be used to say this variety is different than other ones. And by comparing it to something that is commercially known and explaining how exactly it's different, then that gives people a baseline where if somebody else tries to essentially protect your variety or protect something similar, they can say, well, this one basically is hitting all the same boxes as the variety that's already described. And that comparison is how they actually do a PVP evaluation of distinctness. And so by comparing it to the closest available variety, you would be giving all of the information that you would need to get a PVP certificate on that variety, even if you don't want to do that in the end.
So can you get a little bit more nitty gritty and go down to collard greens, something I really know? And let's talk, let's get basic. You were getting there, Julie. Keep going in that direction. I mean, it's an Alabama blue, okay? Can you give me something that I could actually pass on to somebody who's never heard of prior art?
So I don't know Alabama blue.
Okay.
Is it a commercially available variety that's described?
You can buy it on my website.
So that's the one you want to describe?
Yes, and
Okay.
that's the kind of work I need to do, because if a family grew that on their farm, and they claim it, then this is what you told me I could do. I could
Right.
write these descriptions. I need language around that.
I would go to a commercial seed catalog and find a variety of color that looks or is described as the most similar possible to the Alabama blue.
Mhm.
Then plant that next to your variety and compare them over the course of a season and say how your variety differs from that variety that's probably PVP'd or in a commercial sale. And anything that is relevant to a farmer, I would use that as a point of comparison. How long does it take to get to 10 leaves? How well does it bunch? What's the color?
Okay.
What's the stiffness? Does it have waxy leaves? All of the different things that might be relevant. And then also I would look at the PVP website to see what they ask for in terms of morphological descriptors for collards and keep track of those two varieties with those characteristics over the course of a season. And at that point, you've got a very good documentation of that variety. And then you could go into a publication or post it on your website so that at least you have described that variety in enough detail that, say, a PVP examiner could say, oh yeah, that's a different variety. And if I get an application for something that looks like Alabama blue, I can say, well, that's already been described.
So a Clemson spineless is like the standard that everybody uses. So I could use that standard and compare it to that. Everybody's agreeing I could do that?
And can I add just one thing? Make sure you put a date on your publication.
Yeah.
Down to the day is ideal.
Right.
Right.
Benita, did you hear what she said?
Make sure whenever you publish it, put the date that you're publishing it on it. Yeah.
This question is mostly for Tessa. I was just thinking about the idea of using a trademark to kind of build community. It was really interesting. And I wondered if maybe, I guess maybe just if you could talk a little bit more about how you decided to use a trademark to do that and other things instead of material transfer agreements with different growers, and what are like, you know, just kind of illustrating what are the social or cultural and horticultural considerations that were going on there.
Yeah. We use material transfer agreements as well for research, for the transfer of germplasm for research. But for, and we don't, to be clear, we don't sell seed. So we provide a license to seed producers and seed companies that then sell kernels of seed under the trademark name. But that's like little details. So the initial like decision to go with a trademark was really sort of practical. One of the companies that was involved early on was like, if you don't come up with a different name, we will, because we're not going to put intermediate wheatgrass on our label. And so that was one of the things. But then in terms of trying to use it to build space for building community, I think that goal and that decision really have been long-term in the Land Institute. The idea of you know, building seed systems in the common good, for the common good, those kind of things have always been in the sort of ethos of the institution. And so we sort of took on the role of like, well, we'll go ahead and pay for the legal fees, and we'll go ahead and do the paperwork and do all of the things. And in the hopes that then what we can do is sort of build a boundary around the folks who are in this space working together to make sure that it's really clear, you know, what kinds of behavior is allowed, what kind of behavior is not allowed. What and some of that is about grain quality, and some of that is about the sort of social contract of how you have to act with the other people who are involved in the kind of Kernza space. So, you know, we've had some success and had some struggles and all of those things that happen when you're working with a lot of people on different things and trying to create a sort of different system within the legal structure that already exists. So I don't know if that answers your question, but
I have a question. Is there like a community agreement, since you're creating community and you're talking about social contract, you know, contracts?
We do not have a community agreement at this point. We have got like mission, vision, values for what we've called the Kernza Stewards Alliance, which is a business association of licensees, but the legal incorporation, like legal incorporation of that business association hasn't happened yet. So that, but we've done kind of the initial strategic planning pieces.
I'm just wondering if you recommend publishing new varieties, if I breed a new variety, by submitting it to GRIN and describing it in depth in GRIN in a public collection. Is that an avenue for protecting prior art? And does the patent office even look to GRIN? I mean, it seems like it's the most public place to find out information about existing material, but it also sounds problematic from the previous examples of materials being taken from GRIN and then patented. So is there thoughts about how to strengthen GRIN as a tool for protection?
Yeah, that is probably a question for Paulina. You're shaking your head.
Julie, can you explain what GRIN is?
Yes.
And yeah, thank you.
Yeah, so GRIN is the Genetic Resource Information Network, and it is a database from the U.S. National Plant Germplasm System that is also used by other gene banks around the world. They can have their own instance of GRIN, and it is a searchable interface. I think the challenge is if you have a new variety, it's not guaranteed that they will take it in the collection, although they may. It depends on the crop and the resources required. It is also difficult to get enough information into the database to cover every possible characteristic that might be subject to a patent application. So things like specific disease resistances are hard to in advance list out in GRIN, although it is better than many other, just posting it on a website in terms of its ability to be found. I don't know that the patent examiners regularly go to GRIN as a source of information on variety characteristics that are claimed in utility patents. The PVP database is one of the things that they do look at. And so if you go the PVP route with your variety, that documentation is findable to the patent examiners. The other possibility is to, as Emily said, submit a patent application and then abandon it, and it's still there, documenting it, but you don't have to actually go through the patent process. And I think that advocating for more information in GRIN and the ability to put varieties in GRIN that may not always be in the National Plant Germplasm System, that's something that there's certainly interest in making those databases more complete and more accessible. And a lot of the constraints are resource-based rather than interest. And so trying to support those systems and making sure people know how important it is to have accessible information and accessible seed through the National Plant Germplasm System is really critical. And Paulina has done a deep dive on this, so if you want to add anything.
Yes. Okay. So much to learn. So much I don't know every day. I'm like, wow. So I have sort of a clarifying question also about GRIN. I've gotten germplasm out of GRIN when I worked for a research organization. That seems to be the litmus test, whether or not it's like directly related to your field of study. So I've pulled germplasm out of GRIN for purposes of seed increases for communities of origin, say. But a curiosity that came up for me when we were talking about whatever MTA I agreed to by pulling that germplasm is whether or not them having an MTA at all sort of is presencing NPGS or GRIN as the owner of that germplasm. By submitting germplasm, do you basically give away your right to it? Do we know the answer?
So this might also be a good question for Paulina. Do you want to answer that, or?
There's a mic.
That would, yes. Do you want to say anything?
Speak into the microphone though.
So caveat, I'm still very new to the MPGS, but my understanding is yes. If it does enter into the MPGS to become an accession, it has to be publicly available without any restrictions. So you would lose ownership over that.
Yep, yeah, that was what we got to from the discussions we had, and the only reason that they take the PVP accessions, that is in legislation, and then once that PVP expires, it becomes publicly accessible without restriction. So the black box storage
Mhm.
at NPGS does not exist. The idea that you can submit something and they will just hold it for you and won't distribute it, that is not a possibility with NPGS.
But can I clarify, like, you may lose ownership rights, but does that mean that NPGS assumes ownership?
Yeah.
It becomes publicly
Public.
owned. Okay.
Okay, so
And I, just really quick, I asked this question for the indigenous seed keepers in the room who have been approached by folks from the USDA or from GRIN and encouraged to submit germplasm from their protected varieties to be aware of what you might be walking into, whether or not you have the resources to sort of understand the legalese. There's a lot of trapdoors, I feel, so respectfully.
I just want to add that there's actually conversations about rematriating seed. So removing seed from public availability in the MPGS and returning them to their communities of origin in discussion with those communities about what they want to have happen with that material.
Kim?
Yeah, it's quick
Okay.
question. This is not my question, and I'm not going to throw Eva under the bus for not asking it. But do you need a particular power invested in you to legitimize or create an MTA, or can you just be someone who's doing a transaction who can create an MTA as part of the transaction? And if so, is there some way to use an MTA as a strategy for defensive publication itself by excluding patented or privatization as part of the MTA? Kind of riffing off what Solvay's question was, I think.
Yeah, I'll defer to Emily on if you need specific standing. I think you would run into trouble if you tried to create an MTA for something that was clearly owned by somebody else and restricted their ability to do something with it. But I would refer to Emily on whether, like, for public stuff, you need it.
I'm not sure if I totally understand the parameters of the question, but in general, MTA is a contract and anyone can create a contract, but to back up a little bit, the way we talk about property in law is it's not a relationship between the owner and the item of property. It's a relationship between the owner and everybody else. And so if you are the owner, then you can kind of set up to some degree what that relationship looks like and what other people agree to through the MTA. And, as Julie talked about, that's a two-way discussion because you presumably want them to enter in the contract with you. But if somebody else has ownership over the thing, then you can't set up that contract. I don't know if I'm addressing the situation you have in mind.
So quick temperature check. We can push the break, shorten the break and continue this conversation, or we can stop right now. What are we doing?
Is there just?
I'm sorry, Solvay.
I feel like with no response, maybe people need a 30-minute break after the debrief. I'm not really sure.
30-minute?
We'll be around.
Okay, so we're going to move into the debrief. And then we will have a break.